Hello, hello, it's Patty Jo. No, so nice to see you. Thank you for joining me. I know I look terrible today. I haven't even tried. I didn't even put a brush through my hair, to be honest with you. Take the dog to the vet and dropped her off and went to the grocery store. And then I'm here with you. So we're on day 11. It's been a couple days since I've done a video, so I can't really remember where we are. I think that's a good thing. But I'm pretty sure I didn't stop this and start it to check it, so. That's it. Yeah. It's just a break. Oh, he's rolling his eyes. We gotta catch that. We gotta catch that.
Yes or no?
Oh.
Your Honor,
with all due respect.
With all due respect.
I'm supposed to know about the evidence.
The fly, if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks because, again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said exhibity, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been...
Okay, we're reviewing. It is so ironic, is it not, that he complains about being bullied, and he is the biggest bully in the room. Ugh.
And no disrespect directed at Mr. Brooks directly in any fashion.
I don't blame her.
So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant.
Thank you. So
I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
And we are all thankful for that.
I have not heard them, but I'll certainly take the state at its word.
Nobody here needs to hear Math Boy Fly. An idiot. You know, I adopted the name that they called me when I was a kid, Patty Jo. I adopted that back. I always hated it when I was little. It sounded so childish, and I wanted to be so sophisticated, and I wasn't. And the fact of the matter is, when I started working at the fire department, there was another Patty there who had been working there. We looked kind of alike, both short, both dark hair. And, you know, she just didn't want to be mixed up, so she wanted me to go by my initials, but I just stuck with Patty Jo because it was something organic to me. But Math Boy Fly? Oh my God, you were like 40. Like... Math Boy Fly. Oh, Math Boy Fly. Where did he even get that? What? Ugh, I can't.
As an officer of the court, that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination, so the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with
It don't
Detective
matter.
Casey. He's off the stand. He's not
He's
going
gone.
back on the stand too.
No, but I told you I would
No,
recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How
Then he's going to be a martyr about the whole thing. But I want to rebuttal.
am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair
Yeah,
trial.
your butt for sure.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't
There
know
was a reference made
specifically
to
what you're talking
there's a
about,
reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
That's not what we're talking about at the
yeah.
moment. I made a rule.
We know, because nothing you says is relevant to any kind of defense of what you did. So the evidence is stacking up, and it doesn't have anything to do with what you're doing here.
She's
on an
been
exhibit.
laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't.
Darrell. That's a good one. Darrell, let me get this. It's gonna be my little thumbnail. Oh, look at his face. Darrell, she hasn't been laughing at you, but we all have. Because you're stupid. Oh my
I don't
God.
know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
Yeah.
I
for her to sit there-
haven't made any of those observations,
I didn't
sir.
say
What
you.
I've
I didn't
observed.
say you, Your Honor.
No.
But
What I've
for
observed
her,
is
for her, listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot.
No,
That is
that's
very
not-
disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know
Her
what you're
laughing
saying.
under her breath. Her trying to cover up the
Not
microphone
cutting
so
your
they can
fingernails.
laugh and he and key. That they've been doing that the whole time.
Misogynistic with long fingernails.
I didn't
Any
say
specific
anything. I didn't say
instances, sir,
anything
because
about
I
it.
have not noticed that. What I notice are 3 attorneys
Look at him.
who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling
I
involved
haven't
with
noticed
that?
that
You're
other than the
dumb.
one thing you pointed out.
Well, we
today,
have
which that-
cameras. That's what the cameras are for.
Let's refocus our attention on what we're here for, and that's
Okay,
this
then
trial.
I take
and
that
do
as
you have
I
anything you
take
want to put
that
on
as
the record?
I'm putting it on the record
As
if I get a
no,
chance.
you need to let me finish. As it relates to the video and my decision to admit
She
it.
just admitted that she just now came with the exhibit. It was not that she just said she just made it an exhibit. It
That
was
doesn't
not
mean
an
it wasn't
exhibit
turned
before she
over to
made
you.
it one.
So do you have some legal basis, sir, for your position? Because I'm not
What do
aware
I
of any.
need legal basis for when she just admitted on the record that she just made this exhibit up
No,
right
she
now?
didn't. That is
Right
a
now.
complete mischaracterization. Sure, she did not.
That's what. So she wasn't
Create
implying
the
that by saying
exhibit.
that she didn't
She did
pull
not make
anything
it up.
out of her suitcase.
So that's a figure of
During-
speech.
Okay, so what is
Alright.
it implying to? What would that be implying to?
As
How would
attorney-
anyone-
All
how
right,
would
I'm
anyone in
moving
my
on
position-
because you're not providing
How
me
would-
with any
how would
legal
any-
basis.
I didn't even
for
finish.
me to-
You told me that I can make the record. I'm attempting to make the
well,
record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said
anything-
that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you know I
you're
wouldn't get to
providing
that if I didn't
commentary.
finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you opened the door to the playing of that video.
We're not talking about
opening those doors. And the video was
doors.
Previously provided to you during discovery.
We're not talking about opening those doors. We're talking about being fair.
There's absolutely
if
no
I would have did
prejudice
that,
to you.
Your Honor,
In
with all
terms
due
of
respect,
surprise,
with all due respect, if I had done that,
I am going to move on.
If
from
I
this
had done
topic.
that, it would have been
Brooks,
a big
I'm
thing.
advising you.
Are you asking me?
I'm advising you, sir.
Oh, okay.
I'm advising you to sit down and be quiet. And if you interrupt me again, you are on notice that you will forfeit your right to be present in this
So you're
trial.
holding me contempt
Mr.
for
Brooks.
the entire trial? Did you say the entire trial?
I never said any such.
You said for the trial.
How could you-
So what do you mean? I'm asking, what do you mean?
Mr. Brooks, you continue to
That is
come
not.
at me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it relates
asking
to
me
other
to do
things.
that? Are you asking me
I don't need
do
to
that?
ask, I'm telling you. Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics, is my first question.
Okay, why was it an issue with me bringing this?
Mr. Brooks, I'm only going to ask you one more time, and if you don't
I'm saying,
answer it
if I don't
correctly,
understand,
then
if I don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I
a
don't like,
yes or
I don't
no.
like your tone and the way you're talking to me.
Oh my
I don't.
God.
I don't
Brooks?
appreciate it.
Is he trying
Sit
to
down.
correct her?
I don't care if you don't like my
I'm
tone,
not
but
gonna-
you've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too?
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's
Stop
not accurate.
talking.
What you mean, stop talking?
I need to make a ruling. Okay,
Well,
I'm
let's-
purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's
right
talk to each
now.
other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
Yes.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answered
cell?
my question. We'll move on.
I'm
not
trying
taking
to
that
understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're
I
in
know?
recess, 15 minutes
How do
from
I
now.
know
Thank you
what I'm
very much.
supposed to answer if I don't understand? And I don't agree to a stop.
I don't agree to a staple. Yeah. Oh my God. Just use regular words, Darrell. You're already stupid.
Related to what the state just put on the record. Do you know what witness that was?
That was Detective Casey.
Let me look at that. 175 was the screenshot taken from the video. I know I have a note that it was received and published. And you
He is all by himself.
believe I may have just referenced it by the wrong name?
I thought it was 178. I thought you referenced it by the wrong number. So it's either 175. 175 was referenced as 165, or 178 was referenced as 168.
What is 170? I know that 175 is what I just said.
Correct.
What was 178?
178 was the video.
Oh, that was the
video.
most recent one. Okay. What's the request then as it relates to when the jury comes back in?
Your Honor, I just, there's two different ways to do this. I can put on the record, I have the exhibit numbers, and I can just put on the record just to verify that these exhibits have all been offered and admitted into evidence, and the court's agreeing, because we've just agreed that those are, your records are the same as my records, or we can clarify just if there was some confusion about exhibits 175 and 178 that were shown to the jury this morning. Those 175 and 178 were offered, and the court has admitted those into evidence. So however you want to.
All right, sir, do you have any position on how I address this in front of the jury?
Yeah, I'm objected to him being admitted at all.
Well, those objections were already addressed. I'm talking about how I addressed to make sure the jury knows they were received by the court.
However you gonna do it is how you gonna do it. I don't think what I gotta say much matters.
Well, what you say matters, sir, but
No,
the
it don't.
fact that I've already ruled on the admissibility is not something I'm going to revisit.
What I gotta say.
Hold on,
definitely
that door is.
Look,
All right, it's
look at him.
sometimes that door upstairs malfunctions, and all right, I didn't hear the last part of what you said.
what I have to say about anything definitely doesn't matter.
Okay. No,
I take-
you're right.
Huge objection with that, sir.
It's true.
And that may be your perception, but that is absolutely not true. This court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
Sir, can I keep going because you've interrupted me once again? My perspective on all of this, sir, is when you disagree with a ruling, you interrupt, you try to debate the topic again and again, you make disparaging remarks either directly or under your breath that are audible. Sometimes you roll your eyes. I mean, just previous to the break, you and I were talking over each other. I couldn't really get a word in edgewise. You wanted to debate topics that I've already made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey. I gave you multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly. Did I raise my voice? I absolutely did. Was I frustrated? I absolutely was. I'm sitting down. My voice is calm. I think the break was good. I hope for all it was good for me. We had had a very long morning. It was about 11:30 when we broke. It's now 11:54. I didn't remove you to the other courtroom despite my repeated warnings because frankly I knew I was going to take a break. I just wanted to get through some issues outside the presence of the jury, which is the proper procedure for how to address objections if the record can't be done in a way that when a more full record needs to be made, is how I'll put it. And I indicated during the cross-examination of Detective Casey, I would take your objections under advisement. I would address them outside the presence of the jury. You chose not to answer my questions, and so I moved on. Now, with respect to, I want to also
Nobody
address
reads your commentary.
exhibits and the normal course of exhibits coming in a trial. Because I think there's some misunderstanding and certainly confusion on your part, sir, about the exhibit list that I asked the state to file near the beginning. And that was, frankly, to assist the court and my clerk in keeping track. Most trials, the normal course of action is, as long as an exhibit has been provided to a party previously, or in some circumstances, if not, it's rebuttal, we're not quite there yet, that as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented in the course of a trial. There's not a legal requirement.
Wow, okay. In other words, there's no list that they have to stick to. They just present what evidence is appropriate as the case rolls out. Ugh.
Unless a judge orders it, that would prohibit a party from marking a document that's been already exchanged and having it offered as an exhibit. There was nothing improper about what the state did with Exhibit 178. And I want to make that record very, very clear. As Attorney Opper stated, trials are fluid. Things happen. Parties can open the door to what might be inadmissible evidence for a variety of reasons. For example, this court made a number of pretrial rulings related to other acts evidence. Even during your cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that, in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. And we moved on from there. I bet that's happened a half a dozen times in this trial. And that's frankly to protect your rights, sir. The door could have been opened a long time ago to the other acts evidence with Erica Patterson. And I frankly kept it out, despite your questions.
She is casting pearl before swine. Seriously, there's no other way to address this. She is casting pearl before swine. She is explaining to him how his words, even though they are often not grounded in any legal basis, are taken into account. His rights are being taken into account. His presence there, even though he acts like a buffoon, is taken into account. The way things are being presented, all taken into account for his favor. And she is explaining this in the most eloquent and kind way. And he is just ignoring it. She is casting pearl before swine. Writing that down.
So, with that, I want to bring the jury back out. I will ask the state, I'll simply just ask the state, are there any anything additional the state's offering by way of testimony or exhibits, you can then address the exhibit issue. Then I'll ask the state if the state has any additional witnesses, and the state can officially rest. Given the time of day that it is, it's 11:58. I'm not going to have Mr. Brooks start with his opening statement. We'll do that when we come back after the lunch hour. I think, frankly, the time over the lunch hour will be good for everyone to regroup, hopefully get a little bit to eat, and come back fresh. And then we'll have his opening statement and the start of testimony. Before I bring the jury out, there's one other thing I want to do, though. I just need a moment to pull something up from on my computer.
So is that addressing subject matter jurisdiction that you're pulling up?
No.
When would that be proven for the record?
Sir, please don't interrupt me. I need to focus on what
I'm not interrupting you. I'm just asking a question.
All right. I'm not going to be addressing that.
So would it
don't
be
interrupt me right now. I'm trying to do something on my computer.
Would it be
and I need to
proven on the
focus.
record?
I feel it's important at this time to at least give you the advisement pursuant to Special Material 28. It is regarding your decision on whether to testify. I'm not asking you to make that decision, but since we're on the verge of you starting your case and it may impact your opening statement, I wanted to go through the following. Sir, are you aware that you have a constitutional right to testify?
I've been informed.
Are you advised and informed that you also have a constitutional right not to testify?
I'm not advised, I'm informed.
Are you advised and informed that the decision whether to testify is for you to make?
I don't understand the question.
Are you advised and informed that the decision on whether you testify in this trial is for you and you alone to make?
I'm informed. Not advised.
Are you advised and informed, sir, that if you choose not to testify, the jury will be advised that they cannot use that against you? In other words, you have that right not to testify.
I'm informed.
When you make a determination about whether to testify in this trial, I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background. Did you hear me say that?
No, I'll say it again.
Yeah.
At the appropriate time, when we go through this discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not.
What's the significance of that?
So that I can make appropriate findings about the voluntariness, intelligence, and your, whether it's knowing, voluntary, and intelligent, your decision to testify.
So whether I give consent.
Wather.
That's not the legal
Massacres it again.
determination that I make.
He massacres it again. Wather. What does that mean? Wather. Wather. Beefy said it was a candy. Maybe he was thinking about candy. Wather. Oh my God.
It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right. And the jury will be advised one way or the other. There's a jury instruction on that. Did you hear me advise you of all of this?
I'm informed.
All right. Okay, let's bring the jury out then, and we can kind of tidy up the record, and then we'll break for lunch.
Judge, may I remove that exhibit, please?
I think they're right there, so let me just take it.
All right, it's happening.
Jury already coming out.
I'll just stick it.
Okay, so go
All
ahead
right,
and sit
for
it
the
back
jury.
down. Thank you.
Oh,
Subject matter jurisdiction still hasn't been proven for the
my
record, Your Honor.
gosh! Stop it with
Should be proven
your
at some point.
tantrums. Ugh. He's panicking. This is panic.
Thank you, everyone. Please be seated. All right, then I'll turn to the state. Any additional evidence at this time?
State has no additional evidence, Your Honor. May we make a record as to the exhibits?
Go ahead, please.
Your Honor, we believe that the court has admitted all exhibits that have been offered, with the exception of one prior ruling on Exhibit 6. I don't know if you want me to list them all by number, or there are, it's 1 through 78, 1 through 178, but there are some numbers missing because we chose not to offer those exhibits.
Anything specific as it relates to the most recent testimony?
The most recent testimony, with Detective Casey, we moved 177 and 178 and 175, 150, 151, 88, and 89. I believe those were admitted by the court.
That's my recollection as well, but for the jury, exhibits 150, let me start over. Exhibits 88, 89, 150, 151, 177, and 178. If I didn't receive them during the testimony, I'm receiving them now.
And 175, which was the still photo.
Thank you. Sorry, I had to scribble on my pad. And 175.
And 13 and 14. Those are the outliers. I apologize.
I believe those were received as well, but if I didn't
Objection, I
state
think they
it,
was already received.
I appreciate that. I just want to be thorough for the record. 13 and 14 were received as well. State have any additional witnesses to call at this time?
No, Your Honor. At this time, the state rests.
All right, thank you.
Wow.
All right, then at this time we are going to break for the lunch hour. I am going to have everyone come back at 1:30. It's a little bit longer, at least that's what I want to do for the lunch hour today. So all rise for the jury. Thank you. Be seated. Mr. Brooks, anything from you at this time, given the state is now rested?
Okay.
What you mean?
Okay. This is where he's supposed to move for dismissal of the charges as they did not make their case. According to everything I have followed all of this time and all of these years of doing, of watching these, of watching other people cover it, of watching the legal people cover it who know what they're talking about, this is the time where he should be saying that he wants to dismiss the charges. and then she puts on the record that there was another thing that he was whining about, and we all gagged because she complimented him. And somebody commented and I wish I was better at keeping up with your comments. There's so many of them now, and I really appreciate them. I do read them. But somebody said that she does that, the complimenting, even though it is thoroughly disgusting, to put on the record that he is capable of defending himself so that he can't come back and say,
I'm asking you the question. Do you have any requests at this time now that the state has rested?
What requests pertaining to what exactly?
I'll ask the question one more time. Do you have any requests to make at this time now that the state has rested?
I don't understand what you mean by that. That's why I'm trying to get clarification.
I'm not going to give you legal advice. I'm simply asking the question. Do you have any requests to make at this time now that the state has rested?
I don't know what I'm supposed to say to that. I don't understand what would that be pertaining to.
I can't give you legal advice, sir. I'm just asking the question to make a record. I'll ask you one more time. Do you have any requests to make now that the state has rested?
I don't understand.
All right. The other thing I want to do when the jury comes back out is you will recall I read Instruction 101 at the very end of the preliminary jury instructions that just has to do with opening statements. I will read that with the caveat. It will just say that the defendant will now make his opening statement. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statement is not evidence. So I'll read that. I think it's appropriate given that Mr. Brooks deferred his opening statement until the start of his case. With that, we will take our lunch break. It's 12:09. If you could be back here at 1:25 and be ready to go at 1:30 with your opening statement.
I got a question.
Go ahead.
Do I get to present exhibits and stuff like that too and admit them into evidence?
At what point are we talking about? Do you want to use exhibits that have been received during your opening? Is that what you're asking me?
No, I'm saying if I got my own stuff that I want to offer into evidence, which is a question I asked previously.
Do you believe the state has all of those documents that they might be able to assist with? Or are they new documents?
I don't know what you mean by new documents.
Are they documents from the discovery that you have?
They documents of my filings and stuff like that. I'm sure they have copies of everything that I filed.
I guess without knowing specifically what you're referring to, sir, I did give you the admonition previously that you are prohibited from discussing subject matter jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that I want to offer for evidence.
Give me an example, please.
I just did. I said I have filings that I want to offer into evidence.
That's too general, sir. I need a specific example so I can answer the question. What are you referring to?
My filings. Everything
Which
that I filed.
filings, sir?
Every one of them.
Well, they have to be relevant, number one, to the proceedings. Okay, number two, I don't know specifically what you're referring to. You can't offer testimony of yours through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm
filings.
being general based on what I've seen thus far. So are you talking about during your opening statement or during the course of the questioning of the witnesses that you're calling?
Your Honor, with all respect, I just clearly said filings that I filed.
Mr. Brooks, if I understood, I'd answer. I don't understand what you're asking me. You need to be specific.
I've filed a number of documents. I think that's on the record that I filed.
Without knowing what you're referring to, then my answer is no. But again, well, I guess I'll have to wait and see as to when you seek to admit them, whether there's any objection or not, and whether they comply with all of the rules of evidence and the rules of procedure. That's the best I can tell you at this point.
I don't understand what you mean by that. They will only be relevant.
See this book at the front of the desk there, dum-dum? She's letting you use her personal book. It's got all those rules that she just said. So if you want to admit something, you can read it. He is not my cousin Vinny, that's for sure.
Into obviously
Oh my goodness.
the matter. They would be
Sir,
relevant to
I
anything else.
can't answer that anymore.
Everything I
We're going to
say
take
is
our lunch
relevant.
break. It's 12:12. We'll see everyone back here at 1:25. We are in recess.
In other words, you're
So I'm not allowed to offer anything in the evidence.
For the record, I never said that. We are in recess.
So I'm trying to understand.
Oh my gosh. I think the next part is his opening statement, which we're going to do separately. Why is that one? It was replayed. Okay. Let's see if we can get a better picture. We'll talk about this guy real quick. Somebody prints something for president, and he really tried to get some Darrell clout by being a Darrell supporter. He, in my opinion, other people have said things about him and he comes after them, so I'm pretty sure he's going to do the same. I don't think I'm big enough, so I guess I can say what I like. But I don't know what you think. You guys can comment if you like. In my opinion, in my humble opinion, first of all, he was just trying to get some clout, and he had followers. He's got followers. People listen to whatever the tripe is that he spews on the internet, which is, not unlike what I do, but whatever. He's perfectly able to do that. He tried to lob onto this and support Darrell. He has a complete, number two, inability to read the room. Read the room there. You can't read the room. He is 1,000% guilty. He did this. He is a monster. He is a narcissist. Darrell, he is a narcissist. And you, sir, you were just so twisted to think that if you just got on the other side, that everybody would follow you. Nobody. No, I watched videos of people that had you on their shows, which were much bigger than this one, and you would say things and they would tell you you were a fool. You're a fool. And then number three, blames Erica. It's Erica's fault that he did this. You must fall under the same narcissistic umbrella as our friend Darrell. That's why you identify so much with him. Because it's not other people's fault. Your actions are not other people's fault. That's not a thing. So trying to get more clout, supporting this buffoon here, and the goblin, not able to read the room. Like everybody's on the same page. Blaming other people for Darrell's actions, and saying things like, you don't know how black women are and they do this and they do that. That was so distasteful. I saw some of his comments and they were ugly. They were very ugly. And they like the thug like that. I have no idea. I have no idea what that is. I don't understand that. But you certainly didn't bring what you thought you were going to bring to this. Read the room.
A slight issue finding Sir,
Can you sit up, because
I'm gonna bring
I'm
it
not
right up
hearing
to
you very
his
well,
opening.
so that the microphone picks you up, please.
I'm having a slight issue locating some of the files that I need. That's what I was trying to say.
All right, we'll take a moment. You can look. Tell me when you locate them.
Okay.
Misogynistic narcissist. Ugh. Well, this is super interesting.
Your Honor, I have a question.
Go ahead.
The
Duh.
files that I'm attempting to locate are pertains directly to the witnesses that I will be calling. I'm not sure what witnesses are here today.
Well, let's do this. I'd like you to at least do your opening statement, bring the jury and do that. We'll give you an opportunity to look again. I can have the state write down who's here. I believe it's based on what you told them, and then if there's still something you need at that point, but I'd like to at least bring the jury out and start with your opening statement, okay?
Well, just so I'm clear, I didn't give a specific order in who I will be calling by specific order. I gave a generalization of
Sure, I'll
who
have the
would be-
state, sorry.
who would be called on what day.
Why don't I have the state write down who's here presently, and then you can make that determination, but at least let's go with the opening statement, okay?
That's what I was trying to get at. It would help to know who's actually here today.
Before you make your opening statement?
Well, so I know if they're not here, then essentially I can't call them.
Let's address that after. I'll have the state write down who they know to be here now or who's coming this afternoon, because there might have been people here this morning. I believe they're still here, but I'll let them write that down for you so you can better prepare. But at this point, I would like to bring the jury out for your opening statement. I presume you're going to give one.
I am.
Okay. Then
Yeah.
I'll have the jury brought out, okay?
Subject matter jurisdiction.
Oh,
My prior
gee.
written decision stands. I will not be addressing that further. Your objection is noted, and I will be continuing with the trial.
Is it verified proof for the record?
Sir, I don't believe I need to do that, or that the state needs to do that as well. I believe your statement about that is a misstatement of the law, and I do not intend to pursue that further.
Can you show me lawful law that says that?
I
Lawful
gave you
law?
a written decision. I have done that.
Can you show me lawful law that verifies that
Sir,
for the record?
I gave you a written decision. You
That I accepted for value in return for
and
value.
that's
because
how I'm going to answer that.
You
So
it's
let's
not verified proof. We still aren't.
Sir, there is no requirement in the law that the state or the court establish that. So your
Actually,
objection
there is.
noted.
All right. So we're to his opening statement. This is a milestone. Wow. We actually covered a lot. We went a little bit back, covered the hearings. Okay. Comment on some of those things, whatever you think. This guy in the back, whatever you guys know about that would be so cool to know some more. And thank you so much for joining me. Thank you very much. This is Patty Jo, and I will see you next time.